So the state of California's new concealed carry law that directly defied what the Supreme Court said in Bruin was recently struck down. But now the Ninth Circuit is going to step in, so we need to talk about what is happening. But real quick before we jump into this video, if you think California needs to stop violating the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like FBC and GOA. So if you want to get great coffee and support the two-way cause, I highly recommend Blackout Coffee. You can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So as I mentioned in the intro, in this video, I'm going to be talking about a huge win that we received in California. Now, first and foremost, I want to apologize for my voice. Of course, during the holiday season, I caught some sickness, I think from some family. So I apologize for that. And also, I just want to say, hope you all had a Merry Christmas. Now, the case we're going to be talking about in this video is the case May v. Bonta. This is a case that Reno May and I joined as plaintiffs to sue the state of California because of their new SB2 law that they passed in direct defiance to what the Supreme Court said in Bruin. Recently, we received a big win from a federal judge, a federal district court judge, Judge Cormac Carney, granting a preliminary injunction against various aspects of California's new CCW restrictions. Now, with the looming SB2 restrictions going in place at the beginning of next year, this was a huge win. But as we knew, the state of California was not going to be quiet. They were not going to sit still, and they immediately filed for an emergency stay of that preliminary injunction. And the attorneys over at Michelle and Associates, unfortunately, have been working tirelessly over the holidays to try to stop this California emergency stay that they're asking the Ninth Circuit for. Now, before we jump into what happened in this decision and what's happening now with this emergency stay, we need to talk about SB2 and what is being challenged in this specific case. Now, SB2 is set to take effect on January 1st of 2024. SB2 was passed in direct defiance to the Supreme Court's recent 6-3 decision in New York State Rifle and Pistol Association versus Bruin. In Bruin, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. However, states like New York and California decided to quickly defy what the Supreme Court said in Bruin and pass new concealed carry restrictions that in fact were even worse than ones that existed prior. SB2 first enhanced the training requirements in California. It changed the class requirements for new CCW applications from 8 hours to 16 hours, and then also changed the renewal hours for 4 hours to 8 hours. But even before that, before going through that insane training requirement course and the hours you need, your application could be denied under SB2 because law enforcement agencies were required to find essentially some sort of good moral character. SB2 says that issuing agencies can issue a permit if the applicant is not a disqualified person. So really, they're just kind of playing a semantics game, but really what this amounts to is a good moral character determination by the issuing agency. Now, that's the training requirement, which wasn't challenged in this specific case, but what is being challenged in this case has to do with the restrictions on the areas in which you can carry if you go through the process. If you get your CCW permit, what SB2 did and what California did is essentially make your permit so useless that you wouldn't even essentially have a right to carry because they made everywhere in the state of California a sensitive location. And so that is what's being challenged in this law, including, that list of specific locations and then the catch-all provisions that pretty much said that you could not carry at private businesses unless the private business put out a sign that said, yes, you could concealed carry there. So what also happened in SB2 is there was a paradigm shift where now the burden was on the business to say, yes, you can concealed carry here, put out a sign instead of putting out a sign that said, no, concealed carry is not permitted at this location. So California was sued in this case by myself, Reno May, a bunch of other plaintiffs, along with organizations like California Rifle and Pistol Association, Gun Owners of California, and then also organizations like SAF, which is Second Amendment Foundation. There was a different case also filed by the Firearms Policy Coalition in a separate lawsuit. And like I mentioned, Judge Carney granted a preliminary injunction against SB2 and these sensitive location restrictions. Judge Carney issued an injunction against multiple sections of SB2 that put in place various concealed carry restrictions on those specific locations. For reference, these specific locations that are protected by this injunction are hospitals, public transportation, any place where alcohol is sold, public gathering areas, playgrounds, parks and recs areas, casinos, stadiums, public libraries, amusement parks, zoos and museums, churches, banks, and then like I mentioned, the private property owned, that is open to the public. So they got rid of the catch-all provision. The preliminary injunction stops those restrictions. And in the decision, Judge Carney states that we live in dangerous times. Nearly every day, we are barraged with stories about school shootings, attacks on places of worship, and other unthinkable acts of violence and cruelty. Nor are our society's problems limited to those acute acts of terror. Daily, our country faces prejudice and division of all types, economic uncertainty and poverty, a nationwide mental health crisis, and an epidemic of addiction and crime. The only hope to find in the face of such dire circumstances is that democracy, as it has up to this point, will prevail and somehow solve the challenges we face. But such hope is little comfort to individuals who, through no fault of their own, find themselves beset by an attacker and facing their death or that of their loved ones. The right to self-defense and to defend one's family is fundamental and inherent to our very humanity, irrespective of any formal codification. In their wisdom, the founders recognized the need for individual citizens to protect themselves and their loved ones from those that would do harm, and they knew that such a right could not be vindicated without the right to bear arms. The Second Amendment to the United States Constitution guarantees law-abiding, responsible citizens the right to keep and bear arms for self-defense in case of confrontation. For many years, the right to bear arms, and so necessarily the right to self-defense, was relegated to second-class status. But the United States Supreme Court made clear in its landmark decision, DC v. Heller, McDonald v. Chicago, and then also Bruin, that relegation could no longer be permitted. Individuals must be able to effectuate their right to self-defense by, if they choose, reasonably bearing arms. Some disagree with the founders and the Supreme Court that individual citizens have a right to protect themselves and believe that the best solution to the many dangers of the modern day is to prevent law-abiding citizens from carrying handguns. It is not this court's place to question their judgment as to how to solve the many challenges we face. That is up to the people and their elected representatives. But the Constitution, by design, recognizes that some rights are so important and sacrosanct that nothing short of constitutional amendment may take away those rights. No one, not a federal judge, not a state governor or legislator, not even the President of the United States, is above the Constitution. He goes through each specific restricted place and finds that there is no historical support at all for these types of carry limitations. So that was a big win, and it's some awesome language from Judge Carney. Now, of course, we knew that Newsom and Rob Bonta immediately would whine about this, cry about this, and that they would file for an appeal. And that's exactly what they did. They filed an appeal up to the Ninth Circuit, and then they also sought an emergency stay from the motions panel in the Ninth Circuit. Now, if you're not familiar, what happens with something like this with an emergency stay, instead of going to a traditional 3-judge panel, it goes to the motions panel, which alternates every single month. So this emergency request for a stay went to a motions panel. We don't know who's on that motions panel, but what ended up happening is the motions panel in the Ninth Circuit requested some additional briefing on the emergency stay. And unfortunately for the attorneys on Michelle and Associates, they had to respond to this over the holidays because the Ninth Circuit set some of the briefing to be due initially on December 27th. And then what ends up happening is the state can also file the reply to the response by Michelle and Associates on December 29th. So again, unfortunately for those attorneys, they had to respond to this over Christmas and the holidays. So again, make sure you're donating to organizations like CRPA, GOA, and SAF because the attorneys that are representing these organizations were even working during the holidays to try to stop this California concealed carry restriction. Now, you may be asking, what is the likelihood of an emergency stay being granted by the Ninth Circuit? Well, legally, it should not be granted by the Ninth Circuit. A stay like this potentially should only be considered to maintain the status quo. But what California is asking for is a stay on the injunction so that come January 1st, they can completely change the CCW laws in California. And an emergency stay would not maintain the status quo in the state at all. It would do the exact opposite. They would be able to completely change the law and implement SB 2 that's never been in place. They would get to change the laws, and that's what they're asking for the Ninth Circuit to allow them to do. Now, with that being said, this is also the Ninth Circuit, who traditionally hates the Second Amendment, has not issued favorable 2A decisions, especially the en banc panel, and recently they broke their own rules to take control of the Duncan California magazine ban case. So personally, I think this is about a 50-50 chance right now. Hopefully the motions panel that's reviewing this is a favorable panel. they didn't immediately grant an administrative stay. So I think there's a sliver of hope with this. Regardless, we will likely get an order from the Ninth Circuit before the end of this week on Friday, because again, like I mentioned, SB2 is implemented on January 1st, which is, I believe, this upcoming Monday. So the last actual business day to file an order like this would be the end of Friday. So stay tuned. Make sure you subscribe to the channel. Make sure you have notifications on. So if anything changes, if I put out a video, you guys will be notified. But if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But regardless, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.